Hello, everyone. Welcome to today's program. Excuse me, are you recording AI Glasses, Privacy Law, and Compliance? I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Joseph Lazzarotti. Joseph is a certified information privacy professional and principal at Jackson Lewis, where he co-leads the firm's privacy, AI, and cybersecurity practice group. His practice focuses on the intersection of laws governing data privacy, cybersecurity, and AI. He advises multinational and regional companies across industries on compliance, risk management, data breach response, and emerging technology issues in the workplace. A recipient of the Florida Legal Awards Distinguished Leader recognition for 2026, Joe also counsels employers and plan sponsors on employee benefit matters, including health and welfare plan compliance under ERISA, HIPAA, and the ACA. We're so excited to hear what he has to share with us today on this topic, so I'm going to turn it over to him.
Thank you so much. Good afternoon, everyone. Thank you to the Beverly Hills Bar Association for having me. As mentioned, my name is Joe Lazzarotti. I'm a principal with Jackson Lewis. I co-lead our National Privacy, AI, and Cybersecurity Group. And also, as mentioned, I do a fair amount of work in employee benefits, which is anyone who's done both will tell you it's a strange but oddly complementary combination, especially when it comes to HIPAA and ERISA issues. But we're going to talk about AI glasses, and I want to start with the title of this talk because it kind of tells you everything that you want to know about why we're here. Excuse me, are you recording? Which, a few years ago, you might have only asked someone holding up a phone or video camera that question. Today, you might ask it if the person next to you is at a deposition in a courtroom and simply has glasses on, because the technology has advanced so far. Indeed, these tools are not novelties anymore. They look like ordinary glasses, and that's the entire design philosophy, right? That they can record video, capture audio, run AI tools, and stream what they see, all while looking like an ordinary pair of glasses. These devices are not, something that you can't find. There are 7 million pairs evidently already out there, and other manufacturers are racing to ship their versions this year and going forward. So the question is, that person recording me is no longer someone being paranoid. It may be just some due diligence, as we'll see. I think for lawyers specifically, whether you litigate, whether you advise employer clients, whether you sit on an ethics committee or just want to get through a deposition without an evidentiary mess, this technology sits right at the intersection of privacy law, professional responsibility, a regulatory environment that is rapidly changing, and a number of other laws, and we'll cover many of those today. A little quick housekeeping on the next slide is a disclaimer in your materials. Again, this is an educational program. It's not legal advice. You need to get legal advice in specific situations. You can read that as well. And with that, we'll get right into it. On the next slide, we'll lay out the agenda that we want to cover. The roadmap for today's presentation. First, we'll talk a little bit about the technology itself, what these devices actually do. Then the bulk of our time will run through some of the regulatory landscape, including biometric privacy, recording and consent laws, some general data privacy and AI statutes and developments, including workplace surveillance. After that, we'll touch on some of the legal and ethics and professional responsibilities that come with these devices, as well as some things that the California Bar has said. And we'll close with some practical governance framework, whether that's for you in your practice or for what you might want to convey to some of your clients. So on the next slide, let's jump into what can these AI glasses do. If you're not already aware of them and you see the image on the screen, this is from wired.com. You'll see that there's nothing that screams this is a surveillance device if you just saw one of these sets of glasses in person. And that's not an accident. The entire value of this tool, this product, is that value proposition that you can do all these things with a simple set of eyewear, not a complex piece of equipment or even something that we are used to seeing more generally that records and performs similar tasks. So what can they actually do? There's 5 things that are worth considering or inventorying if you're going to use a device like this new piece of technology. One is hands-free camera and audio capture, including, in some cases, live streaming. You can perform AI-assisted transcription, translation, and real-time analysis of what the device is capturing. There's Wi-Fi and Bluetooth connectivity, so that means you can store data that you're capturing with the device in places that you may not always control. There's a heads-up display, as you can see there, overlaying AI-powered information in real time. And there may be biometric sensing, including some implementations for facial and voice recognition, although that's seen some controversy in the last few months. We'll talk a little bit about that. So there are some real values to this with hands-free workflows, better training capabilities. A partner, for example, or an associate can literally see what others in the firm are doing on, let's say, a site visit if they wanted to get more information about their case. There might be abilities for enhanced client interactions and some useful ways to document things like inspections or witness walkthroughs and so on. But these same capabilities that we're talking about, as we'll see, create some compliance challenges many existing laws never really anticipated. Recording statutes assumed tape recorder sitting visibly on a table. Biometric statutes were written before a camera built into eyewear was a realistic fact pattern. We're applying 20th century statutory language to a wearable that didn't exist when the language was written. So it creates a gap that we need to be thinking about as we adopt these types of technologies. On the next slide, what you'll see is the slide after that, sorry. This slide will get at the list of policies that you will find applicable to Meta glasses if you want to really dig into it. And this is the actual list from the website of the legal documents that governs these tools. So there's a supplemental Meta platform technology terms of service. There's a privacy policy. There's a supplemental Facebook view policy in terms of service. There's a U.S. regional privacy notice, health and safety information. There are voice controls privacy notice. There's even a wrist input privacy notice. That's right. There's a separate notice just for the wristband. There's a Meta View third-party notice, an early access program agreement, a creator affiliate program agreement. So in total, about 11 documents. Just as an aside, if you are also providing advice to clients about adopting these tools and you bill by the hour, reading all of this for a client may not be a bad project to get. But seriously, the reality is that very few consumers will work through all of these documents before buying these glasses. And so again, that creates a gap between what is technically disclosed in the documents and what a user comes to understand before using them. And that really is a key issue that also is the subject of a litigation we'll get to in a minute. So on the next slide, we'll see that we're going to jump into some of the regulatory landscape that is facing these technologies and companies that want to use them. AI glasses really sit at the crossroads of biometric privacy laws, two-party consent states like California, basic data privacy and AI statutes and cybersecurity rules, as well as labor and employment law, and we'll take each of those in turn. So first, we want to consider biometric compliance issues. There are federal laws that address biometrics generally, along with other types of data that fall into the particular regulatory environment. For example, if you're collecting a biometric in the context of being a healthcare provider, you're probably going to be focused more on HIPAA. It's really the state laws that raise a lot of the issues for entities or individuals that are collecting and using biometric data. In California, you're probably very familiar with the California Consumer Privacy Act. There are similar laws, similar comprehensive privacy laws in about 21 or 22 states. But the CCPA obviously is going to be most important for those listening. And it too captures biometric information as a type of personal information. In fact, it's in the category of sensitive personal information under the CCPA. If you're not familiar, there's the Illinois Biometric Information Privacy Act, and that's really important because it has a pretty robust enforcement scheme that allows aggrieved individuals to sue and get $1,000 in remedy without showing any actual harm if a company that collects their biometric information doesn't comply. And there are other states with similar biometric privacy laws, specifically Colorado, New York, Texas, Washington. They all have their own frameworks now, and the use of these glasses could trigger those frameworks depending on certain circumstances. One thing to note when you look at those other state laws, including with California, is biometric information isn't always defined the same way. But in general, it will include the collection of a face scan or a voice print. But it could also include someone's gait, how they walk, for example. That is considered biometric information, which is something that biometric glasses with biometric capabilities can capture. Functionally, AI glasses, again, can capture face prints and voice prints, even gait, just by being near people. You may not even intend to do it, but that information potentially can be collected and meet the definitions that I mentioned under these statutes without someone deliberately trying to do it. For attorneys specifically, wearing these around clients or opposing counsel or witnesses may capture these markers from people who never consented to it, never got a notice of it, or any idea that it happened. If, for example, you're working on a healthcare matter and you're visiting your client and you're walking through the facility, you might be capturing information about patients or family members or physicians. Again, that could be considered PHI or just simply personal information about those individuals, not just biometrics. And so you want to be thinking about that as you're using these devices in those contexts. And so, when you think about the unintended data collection that can undermine even a carefully built data minimization program for CCPA purposes, that can become a significant issue. To kind of take a step back, if you're subject to the CCPA, it requires that you only use data that you have a need to. In other words, you want to be thinking about only collecting the data that you need. And that presents an issue with these types of glasses because as you use them, you're collecting a lot of information and you may not really need it for the purpose that you're using it. I mentioned something about facial recognition, and it was recently reported that one manufacturer of AI smart glasses had included an unactivated software called NameTag, which was an unreleased facial recognition system, and then that manufacturer removed it entirely and has no active plans to launch that feature. So facial recognition, though, the point is that it is not necessary to have facial recognition to also collect biometric information. So while you may have heard in the news that facial recognition is being withdrawn, it doesn't mean that the tool is not also collecting biometric information. I want to also mention one other thing, and that is that we mentioned inventorying earlier, inventorying the different features of these devices. And that's really important, not just for AI glasses, but for any tool that you're using in practicing law. Knowing what those devices do will become really important, particularly as we discuss later on some of the ethical rules. And consider that for any device or technology that you deploy in your business, it's really critical to understand and to inventory what those features are and when they're being used and how they're being used. We're discussing here the potential ability to collect biometric information, but as we'll see, there are other capabilities that these devices have that you need to be aware of in order to be able to assess your legal, ethical, and business risks. Next slide, please. So the second area is consent and recording laws. And as you know, California, under its California Invasion of Privacy Act, it makes California a two-party consent state for audio recording. So everyone being recorded has to consent in essence, unlike federal law and a lot of other states where you only have a one-party recording requirement. Video capture in areas with a reasonable expectation of privacy raises separate state law exposure, and AI note-taking and transcription raises the stakes further. Someone can now generate a full verbatim transcript of a conversation continuously without anybody in the room knowing, just having a pair of glasses on their face. Companies, including law firms, are grappling nationally with AI note-taking and transcription tech as they raise client confidentiality, privilege, data security, and a host of other issues. And that is for the application of a more deliberate application. In other words, the issues that companies are dealing with transcription is something that people have to enable, or at least allow the default to go through. These devices are designed to be passive. You wear it on your face and they will work and capture this kind of information and produce these transcripts. And it may become second nature. So you really want to be careful and be aware of what the tool is doing to avoid unintended consequences. So think practically, who's wearing the device? Is it a client? Is it a witness? Is it one of your associates, the attorney themselves? When are you doing it? Is it at client meetings, in courtrooms, at depositions? One concrete scenario is a manager may be wearing an set of AI glasses while doing a performance discussion with a subordinate who has no idea they're being recorded. They may be biometrically profiled or assessed, or there may be a transcription of that conference that they're having with that person. So it really isn't hard to imagine a situation in which an individual present in a courtroom wearing glasses could create a stir. This includes the Los Angeles County Superior Court, for example, where recording generally is prohibited. Lawyers whose clients have those devices should not be surprised if they sit in a courtroom and the judge discovers it and orders everyone wearing the glasses to remove them immediately and to delete any data that is captured by the device or they may be held to be in contempt of court. So, as noted above, the design of these devices is intended to be integrated naturally into an everyday traditional pair of glasses. And users may forget that they're wearing them. They may not think about it before stepping into a courtroom or a deposition, and that may become a significant issue in the case. So when you're prepping a client or a witness or yourself for a deposition, you want to be having that front of mind. You don't want to assume that people will volunteer that information, and they may not even genuinely think about it. So in your pre-hearing checklist, right next to where you say to silence your phones, you may want to add a question about, does anybody have glasses or other recording devices that we need to be aware of? Next slide, please. So another issue with AI glasses is the ability to collect information, as we've been talking about. But then there's this, in addition to biometrics, in addition to generally recording video and audio, it's the type of data that you're recording that you want to think about. So you want to kind of think about this set of privacy and cybersecurity laws that we've been grappling with over the last few decades, really, in terms of data breaches and uses of that data, and a lot of regulatory frameworks that we've seen develop over the years to address this issue. One thing is, I've noticed, and just speaking with companies, is that particularly for smaller business and some law firms, people in retail, people in customer service business, people who like to advertise and reach out to their consumers on social media, what they find is that using these glasses really facilitates advertising and getting the word out about their business. They could be at an event and they can have their glasses and record a snippet of a video and very quickly share that experience with a client or an opportunity on Facebook or LinkedIn and showcase their business. And in that process, they might use or have someone's image in that video, but never get their consent. And in many states, including California, there's an obligation to get someone's consent before you use their image or likeness for a commercial purpose. And sharing someone's image to help promote the business might very likely be a commercial purpose. So you want to really be careful about, despite having the ease of the technology that allows you to do that, making sure you're getting that consent and using that video only with the consent. In addition, you might be collecting sensitive information, and really not be taking appropriate steps to protect it. And you can be capturing that information, whether it's on a screen or a document or really anything in the user's field of view. And we're not just talking about, a social security number, sensitive personal information that could be subject to an obligation to have to notify someone of a data breach is pretty broad. California has a breach notification statute, and it goes far beyond just a name and social security number. It includes financial account numbers. It includes biometric information, which we talked about. It includes medical information. It includes account credentials. It includes other state identification numbers. So if you're walking around with glasses and you're pointing at a desk and that's capturing documents, or you're at a counter where other customers are paying a bill or talking about information about their health or a family member's health, you may be capturing all of that information and storing it somewhere that may be in an account you're responsible for, and that account may get hacked. And then you'll potentially be obligated to notify those individuals, some of whom you may not even know, but you may have had an incident like that triggers that kind of obligation. Taking that a step further, depending on the context in which you're creating that information or capturing that information, you may have a different set of requirements. I mentioned earlier walking around a hospital or visiting a healthcare provider client. Again, in that case, if you're representing that healthcare client, you will likely be a business associate. And in that case, you have obligations under HIPAA to safeguard that information and to notify your client if there's a breach of that information. So again, thinking about how you normally interact with clients, how you walk around, these glasses are intended to basically be second nature, and the collection of that kind of information could create some unintended consequences if you don't have the appropriate safeguards and controls to protect that kind of data under a particular regulatory environment like HIPAA. So you'd definitely want to be aware of that and think about limiting your risk there. And then kind of lastly, on the types of legal points that might be generated by the tool, there are a set of emerging AI laws that and you'll see this in legislative proposals that are creating this bevy of new AI requirements for certain use cases that could affect these types of tools. And that centers around particularly decision-making tools. So suppose your glasses will capture a meeting with a job candidate, and it will permit the assessment of impressions about the candidate, or even make or substantially make a decision about that candidate, whether they move to the next interview or whether it ranks them among other candidates. These applications are potentially something that could be used with these types of devices. That type of decision making might trigger obligations, including under the CCPA. If you look at some of the new rules around automated decision making technologies, you might have obligations to provide notice. You might have obligations to allow the applicant or another individual to opt out of the use of that information, or you might need to think about whether it is creating a bias. Now, that may not be with the glasses specifically, but it may be with the tool that the glasses incorporate that allow those analyses through AI to be performed. So the collection of information generally triggers concerns about the types of general data privacy, security, and AI laws that I mentioned. And again, I want to emphasize the issue about the concept of data minimization. You really want to think about how much data you're collecting and when you're using it with this technology. And is it really necessary? Do you need to keep it? So you'll want to think about data storage, and you'll want to think about document destruction as well, and also who has access to that data when it's stored. So all of these types of things could, again, not at the moment, but maybe down the road, create some liability should something happen to that data. You'll also want to make sure that you think about when you're processing data, including with the types of cybersecurity controls that you have. This will include monitoring how the product or the terms of use may change over time, and that may affect your risk as well. So you may only purchase a device with a certain set of tools or capabilities, and that may change. As you continue to use that tool, you may have new features that are deployed by default, and you want to make sure that you're compliant with that. You may have contractual obligations with your clients about how you're using a particular device, and it may address how you store their information. And so you want to be aware of that, aware of what your device can do, and make sure that's consistent with what obligations you have to collect client data. Next slide. Another issue we want to talk about, which is kind of related, but more in terms of how it works at your workplace and what you're doing with your employees and other personnel at the office. For those also doing employment counseling, you may want to think about this as well with your clients. Pervasive monitoring in a workplace can raise certain state privacy issues. It could run into common law protections when someone has a reasonable expectation of privacy. It could raise issues under the ADA for protection of confidential medical information. GINA for genetic information could raise CCPA issues. There may be other state laws that get triggered depending on what's captured and how it's used. In states like New York, Connecticut, Delaware, New Jersey, and most recently Maine, monitoring employees may come with certain specific requirements that may include notice, an acknowledgement by individuals, consent even. Those obligations could be triggered by one or more features of these glasses. In California, in particular, the CCPA recent regulations create an obligation to perform a risk assessment, for example, with respect to certain types of processing that you want to be aware of if you're subject to the CCPA. So, for example, with limited exceptions, processing sensitive personal information, which is a defined term, like geolocation, racial or ethnic origin, religious beliefs, genetic data, biometric information, health information, sexual orientation. Processing that type of information requires a risk assessment. Also, profiling a California resident through systematic observation while acting in their capacity as a job applicant or a student or employee or independent contractor also can trigger a risk assessment requirement. And that includes having to submit a report to the California Privacy Protection Agency on a periodic basis. So you really want to understand, is your device performing these functions? And that may trigger this obligation to perform that kind of an assessment. And for purposes of systematic observation, that means the methodical or regular and continuous observation, includes video or audio recording or live streaming, features that are very common to these glasses. Another issue I wanted to raise is that the NLRA, the National Labor Relations Act, deserves some attention, even if you're not a company that has bargaining employees, because that law requires that you make sure not to chill protected concerted activity. Now, my non-labor definition of protected concerted activity is a right that employees have to engage with one another about working conditions. And one of the concerns about the National Labor Relations Board is that a sweeping surveillance environment might chill an employee's belief that they could engage freely with other employees without being monitored by the employer, and might have some repercussions from talking about workplace conditions that they're not happy with. So a blanket no recording devices anywhere policy might become a problem because it might be suppressing Section 7 rights. And so you need to think about a policy that's narrow to survive that kind of scrutiny, but broad enough to actually manage the risk. Union disputes also can arise from wearable technology if it's not bargained with in appropriate situations. And even without a union, as I mentioned, there's this big brother atmosphere that pervasive recording can correlate with negative worker engagement. So you don't need a lawsuit to have a problem. You can just have a workforce that no longer trusts having ordinary conversations. And so those are some of the workplace law issues I wanted to address before moving on to a potential law in California that you might want to be aware of on the next slide. I think this is going to be an important development to watch in California, but also in other states as well. If you haven't seen it, SB 1130 is moving through the legislature right now, and it's likely going to be one of the first laws that are written specifically to deal with this type of technology. The law was introduced by Senator Eloise Gomez-Reyes, and it would prohibit recording individuals in certain business settings without explicit consent. It would prohibit disabling the required recording indicator light. If you're not familiar with these technologies, they have a light that shows up that indicates that they are actually recording, and so blocking that or inhibiting that alert to other persons it would be a violation. They also prohibit selling or manufacturing. The law would prohibit that technology designed to circumvent the notice requirement. So this bill is not stuck in committee and likely to die. It seems like it may have some legs. As of late last month, it passed the Senate and moved to the Assembly in California. And it does have some penalties associated with violations up to $2,500 and up to a year imprisonment for individuals, with separate provisions that also reach manufacturers and distributors of certain technologies. So the issue about the indicator light isn't theoretical. There are actually tutorials on how to circumvent that. And so it's something that I think is, potentially can become an issue if the statute gets passed. So if you have clients that are in retail, hospitality, healthcare, or other client-facing businesses, you may want to put this development on their radar. Next slide, please. There's also some litigation around these devices in Baritone versus Meta that was filed earlier this year in the Northern District of California. Plaintiffs are alleging that the companies marketed the glasses as being designed for privacy and controlled by the users, but maybe from the plaintiff's perspective failed to disclose how data would be collected and how it was actually processed. The allegations include that the glasses continually collect audio, visual, and contextual data when AI features are used, that data may be transmitted off the device. Portions of the recordings, which in this case, footage from inside people's homes, are reviewed and labeled by contractors overseas as part of training. The plaintiffs also allege that they were never clearly told about that review and about the features of the product. Although, as we talked about a little bit before, there are certainly a lot of policies and disclaimers that we saw on the Meta site. So whether these allegations are true, what they do highlight is a critical aspect of this and really any technology that is being deployed by an organization, particularly any device that collects sensitive personal information about clients, which for us as lawyers, we owe an ethical duty of confidentiality. So it really is important to remember the long list of terms of use and policies we referenced. It's critical to review those policies and understand how the technology works, not just when it's purchased, but as functionalities of those tools change and expand. So you really have to keep up with updates to be sure you understand what the default configurations are, how you might be using a particular feature that you weren't aware of or thought was available at the time of purchase. One thing to remember is that, in a separate but related context, the most popular password that is currently in use is 123456. And that's not because people select that password. It's because that's the default in many cases. And the same is true with a lot of technologies that are rolled out. The default option may be to record or to apply an AI tool to analyze data. And you may not always want to use that. You may not always be permitted to use that in certain circumstances. So you want to understand what the default requirements or configurations are so you can make the right decision about whether you want to use that functionality or not. Also, if you do consumer protection or class action defense, this particular case is testing how far design for privacy marketing can stretch before becoming actionable false advertising. If you do employment counseling, the same expectation mismatch problem applies to your corporate clients' own policies with or without AI glasses. And really for anyone, if you're a potential bystander and someone's recording, maybe you're in a courthouse or somewhere else, you may have to think about these issues. So, really in short, undisclosed recording device worn by someone you don't know or may not be someone that you would expect to misuse that information could become a significant issue. And that's showing up here in this case, and we'll see how that turns out. On the next slide, there was some guidance that was issued a few years ago that I think is relevant to mention by the EEOC. This guidance deals with wearable technology generally, and it mostly deals with imposed wearables or situations where employers are requiring their employees to share data from personal devices. But the underlying principles here, I think, also apply, even for devices that you may use voluntarily. And in that guidance, the EEOC warned that employer-imposed wearables could collect medical status information like heart rate, for example, and that could implicate the ADA. A mandated wearable collecting vital signs, needs to have an articulable business necessity. You can't just, go around requiring employees to provide their heart rate and other certain biometrics. And, it's worth noting that some smart glasses can collect and analyze a user's health data, such as heart rate, blood sugar levels, blood pressure in real time. So, suppose you require an associate to wear glasses, AI glasses, while visiting a client's location, perhaps to better understand the facts of your case, and so you can get a better sense of it without actually going on site. And those glasses could be collecting health information about your associate, and that could raise inadvertently an ADA issue that you really hadn't thought about because you weren't thinking about what those glasses, what that device actually does. And the same logic really applies in a Title VII case where a wearable might inaccurately differentiate between certain protected characteristics. In the EEOC's case, the example that they give is reduced accuracy in facial scans for darker skin tones, and adverse action may follow from that, potentially causing a Title VII problem. Employees may need accommodations for religious, pregnancy, or disability-related issues when dealing with certain wearables. Again, something to think about when you're using those types of devices. So, as a practical matter, you really want to run any type of AI glass capability or wearable technology through the same individualized documented analysis as any other workplace technology requirement, thinking about business necessity, thinking about disparate impact, thinking about accommodations that may be helpful before you actually roll that technology out. Next slide. So want to pivot a little bit to the issue of legal ethics and professional responsibility that we have as attorneys in connection with the use of these types of devices. What AI is involved, how are the glasses configured, what does that mean for our professional responsibility as lawyers? I had the opportunity yesterday to, as a member of the Cybersecurity and Privacy Committee for the Florida Bar, to present to attorneys there at the annual Florida Bar Conference about incident response plans and data security generally. And we emphasize that the duties we all share and struggle to apply become even more pronounced as various technologies advance. Rules like confidentiality, client confidentiality, and attorney competence, and supervising associates and others, present challenges in the practice of law, particularly as circumstances and technologies change. And this is really no different for attorneys who want to integrate AI glasses into their practice, or attorneys who have to consider the use of those devices, not by themselves, but by clients, by adversaries, and others. And so maybe, in terms of a place to start thinking about this generally on the next slide, even when you have, strong organizational AI governance or similar policies and procedures, lawyers carry an independent layer of ethical obligation. So this goes beyond, just the policies that your organization may have. You as a lawyer have to think about this individually. A firm's AI policy is not a substitute for an individual's professional responsibility, and those two run kind of on parallel tracks. So types of common risks that we see are confidentiality and privilege exposure with regard to prompts or uploads that may happen, again, not just in an AI LLM that you're using, but also now on these types of devices, which again may occur without you even thinking. You may kind of forget that you have these glasses on and that the tool is working as intended. Remember that anything that is captured or processed through an AI on a back end carries the same risk as pasting a confidential document into a chatbot, into an environment that you may not have vetted, may have accessibility from other sources that are not permitted. You may also have to think about how do we supervise the tools and that are used by our associates, our non-lawyer staff, and in the process, what effects are there on how we bill? What effects are there on the scrutiny of the efficiency that we get from using these products, and how does that translate into what we disclose to clients, how we're charging them for our services? And then, of course, what happens when we go to court? How does that affect our duty to have candor to tribunals, including, again, we see the issue of fabricated hallucinations and so on with AI-generated materials. So these are all issues that we'll cover in the next couple of slides, but this just kind of gives you an outline of the requirements that we have to think about, not just the statutes that we talked about and that we're probably familiar with and that our clients are asking about, but our own ethical obligations to use them. So on the next slide, just to start, talk about ABA Formal Opinion 512 that was issued a few years ago, and it talks about generative AI risk and applies them to the model rules. And given the capabilities of AI glasses, these issues need to be explored by attorneys that use these tools. So when we think about some of the common rules that apply to us as attorneys, I've listed a few of them here that I think are relevant for us as we apply these technologies to our practice. And the first is competence. So really understanding, as I mentioned before, how these glasses work is critical to making sure that we're acting as competent attorneys in our practice. As I mentioned earlier, going through that inventory, understanding the capabilities is going to be really critical to satisfying this duty. And again, it's not just with AI glasses, but it's with any technology. And the point, I think, under this rule is not that you have to become an expert or you have to become an IT expert or an AI expert in order to satisfy this duty. It's really just understanding the practical uses of the tool, how it works, what data is collected, where the data is stored, who has access to it. Claiming not to be an IT person is not going to satisfy this rule. You'll have to dig into a little bit of understanding the things that I mentioned, but it's okay also to get some help. Maybe it's through the company, maybe it's through reading the policies, maybe it's through your managed service provider to say, hey, how are these tools working? Where are the pitfalls? What if I did this? What if I did that? What's happening to the data? What is it actually collecting? Answering these questions, asking these questions more importantly, will help you to improve your level of competence and then to make decisions based upon that information that are in line with your overall set of ethical rules, as well as the obligations, the statutory requirements, and in some cases, your agreements with your clients in order to meet this duty. There's also a duty of confidentiality. Obviously, that's implicated whenever client information is collected. This includes video, audio, AI prompt. Of course, this raises the attorney-client privilege. Over the past couple of months, we've seen courts take positions regarding the use of LLMs and the impact on the privilege. That's beyond the scope of our discussion here today. But considering how easily these devices can passively capture information and how communications could be accessed by persons or entities that should not have it, it really does raise the issue of making sure that we are vigilant around securing the privilege for clients. Candor toward the tribunal, a significant risk here may be kind of what we've been talking about in terms of just wearing these glasses and becoming used to them, and then showing up in court and the tool is recording and you may not be aware of it. And as a result, you may not disclose that to the court. Even if they ask, you may not just be aware of it. So we have to be concerned about that as well. And then I think perhaps one of the bigger issues here is supervising other attorneys and staff at the firm, because you may have perhaps younger attorneys and staff who may be more inclined to adopt this technology and sensitive to its risks. So partners should not just be thinking about their own use. They may need to think about who else in the firm is using these devices and what steps they should be taking when they're using them in the practice when doing work for clients. On the next slide, we'll talk a little bit about what the California Bar Standing Committee on Professional Responsibility and Conduct has spoken about recently regarding AI. I think there's some issues there that will have an impact on AI glasses. The guidance that was issued in 2003 is not a new rule. It really just interprets and applies including some of the existing rules we just talked about for professional responsibility in the context of AI. But again, I think that this is going to be relevant for AI glasses, particularly which is using this technology, again, perhaps passively, and we're not aware of it. So in addition to the items that we discussed above around competence and confidentiality, the guidance that's represented here advises attorneys to consider whether clients should be informed that AI will be used in the representation, particularly where AI could materially affect the representation or create risks that the client may need to have an opinion about. So if you're planning to use these devices in some way as part of your work, you want to consider whether client notice needs to be provided. And that notice might need to address how you'll use that tool, as well as the benefits and risks, so that the client could make a decision about whether they think that makes sense or not. It's important to know that this guidance was recently updated in 2006 to expand its coverage to address emerging agentic AI, and really the concern there being AI tools that could be more autonomous in how they perform workflows and tasks. The Standing Committee emphasized that even with AI, even when AI acts with a high degree of autonomy, lawyers obviously still retain responsibility for competence and confidentiality and supervision and all the rest of the ethical rules that we talked about. So the more autonomous you find that a tool is operating, the more important that oversight and preparation and inventorying becomes, including with respect to AI glasses, which may not now, but certainly in the future, have greater autonomy when they are integrated with AI tools and technologies. Next slide. So pulling together a lot of what we talked about, should a client call tomorrow and start asking about AI glasses in their operations, in their workplace, or maybe they're thinking about how you may be using them on a particular matter that you're working on for them. It can be helpful to have a bit of a defensible framework, not just for your firm, but maybe your client needs help with making sure it has taken appropriate steps to integrate this technology into their operations. So we wanted to kind of close out the program by kind of going through some compliance and best practices steps that you can take to help minimize the risk while also maximizing the benefits of these types of technologies that are becoming available. So, a practical kind of punch list of things to think about. First, as I mentioned, inventorying and assessing the risks of specific features, and then deciding, should we permit them, should we deploy them in the environment, is really a critical step. I would also think about, I know we talk a little bit about policies. One of those policies should be thinking about who in the organization is going to be the ones managing this, and what obligations do they have to address changes that may come. So you can imagine a company adopts these devices, hands out glasses to employees for certain use cases, and maybe it's the IT team that is managing them and has the direct relationship with the provider. And 6 months later, after you've gone through a pretty detailed analysis and assessment of risk and made the decision to deploy, 6 months later, there's a new feature that is made available. And the question is, does the IT team come to you with that and say, hey, this is a new feature, should we deploy that? They might just make that decision on their own. The point is, you might want to have a policy that says, hey, we need to consider that policy. We need to have the appropriate people analyze that and make sure we really want to deploy that. So understanding at all times, again, what the tool can do and what you want it to do is really going to be an important point. And then, having policies and procedures addressing how these tools are used can really be a critical issue. And also, once you make the policies where you want them to be, you want to also make sure that employees are aware of them, they understand how to use them, and what tools they may need to deploy them properly. So, for example, if you do happen to have a use case that might require a consent of someone whose image gets captured, you might want to have a sample consent that employees can use. You also may want to have the policies make clear what you don't want to be used. You may want to make clear what locations should not be in view or captured by the device. You may want to lay out specific permitted uses and impermitted uses of the technology. That may include making sure that any data that's uploaded is only uploaded to firm-owned systems and not a personal data storage account or someone's personal Dropbox account or what have you. You want to make that clear in the policy. So there's a lot of different policy considerations, and that's going to depend also on what are the use cases for those policies and what clients may want or not want you to do. So again, it's something to really think about and dig into as you decide whether to deploy this particular technology. As I mentioned, training is going to be critical, not just about when and under what circumstances, but also how to use the device, when to require notice, having employees understand what the capabilities are, what the privacy boundaries are, what some of the limitations are, and just general awareness. I think having a way of reminding employees about this is going to be critical, as well as understanding, even if your firm decides you don't want to use glasses, I think even some type of training and awareness so that your lawyers and staff understand when other people are wearing them so that they can be sensitive to the issue as well. Because someone else capturing that, maybe your adversary, if you're not aware of the technology, you may miss something that could be an advantage in your case if an adversary is using this technology improperly. So that can be something that can also help the practice as well, just by creating that awareness. Thinking about the kind of the technical controls that exist in these devices, you again want to think about what are the default settings and making sure that if you don't want something to be operating, that it's disabled and that you test that it's disabled properly. I'll just tell you a quick story that we had a client that had decided that they did not want to permit users of company-owned laptops and tablets to be able to sign on using a biometric. And they In addition to having a policy, they also disabled that feature on all of the devices. What happened was when they rolled out a new operating system, the operating system restored all the devices to default settings, and default settings permitted those biometric sign-on features to be reactivated. And no one thought about that. The IT team wasn't thinking about that feature. And so what ended up happening was all of a sudden employees again became able to enroll in that feature and begin to log into the device using a face scan, which created a significant risk in states like Illinois and California and Colorado. And that had to be addressed once it got brought to the attention of the company. But the point is that continually managing those technical controls is really going to be pretty important to ensure that you're compliant. In addition, you may have the technical controls, the technical features managed by a third party. You may have an outside IT firm who really helps you with this. Again, going back to the ethical rule of competence, it's not enough to just turn that over to a third party. You really want to understand what that third party is doing, what their capabilities are, have a dialogue with them about the tool, about what it does, about what you want it to do, and some verification that it's actually doing that and that they're performing the services that you're expecting them to perform within the guidelines that you communicate. So, it's not going to be a good idea to just pass that along. You do want to be engaged with the third party. You also want to assess their capabilities in terms of data storage in the event that the vendor is storing data from these AI glasses. You want to make sure that the vendor has appropriate safeguards in place. And you may find that in some cases, depending on the type of data you're collecting, you may need to have certain contractual clauses in your agreement to satisfy things like HIPAA if you're a business associate, or if you're subject to the CCPA, the vendor may be a service provider, and there may be some required contract provisions you have to have. I'll also mention that you want to, if you haven't already done so, and just thinking about the conference I was at yesterday, updating your incident response plans to think about this technology that could have data that's caught up in a data incident, and how to protect the technology, and also how to understand what data may have been captured if there was some type of compromise to your systems, because that could create obligations to notify. It could become something you have to make sure gets investigated as part of an investigation of a breach. And so that's something that you want to think about as well as you're going through and putting in place some best practices. And so, really to kind of close it out, this idea of, excuse me, are you recording? Again, it used to kind of sound paranoid and something that you weren't always thinking about. But today, it's really just a matter of simple due diligence, understanding what's going on around you, understanding what kind of information you're collecting, whether you're prepping for a deposition, walking into a courtroom, client meeting, or just going down the hall. What these glasses can do, create a whole range of issues. Something you see might just be glasses, but they might be a very complex device that you're wearing, and it is something that you want to really think about carefully to avoid legal risk and making sure you're meeting your ethical obligations. So with that, I'm happy to look and see if there's any questions. I don't know if there have been any submitted, so I'm checking here. I don't see any. I don't know if there are any in the chat. Let's see. Doesn't look like there are any. So, here's one. The question here is, on the opposite end of professional practice, how does one protect oneself from non-consenting recording in public when you have a certain presumption of privacy from biometric recordings, etc.? I think at some point there may be some inadvertent collection. I think you want to try to be careful of that. I mean, I think that's part of having that indicator light in SB 1130. Arguably, you may have an argument that the indicator light would have provided notice, and the person who spoke after having seen that light may have given implied consent. That may be one argument. Um, if you come into a room, I mean, I don't know that many people are going to announce to a room full of people that they have AI glasses, but I do think that's one possibility, that having that light be conspicuous and not blocking it may be one way to protect yourself from that. Another way is to be thinking about, you know, do you want to be recording in a particular environment, and disable that feature when you get into that environment. So I hope that answers the question on that one. If there's any other questions, I'd be happy to answer them. Okay. Well, thank you very much. I appreciate you listening to the presentation. I hope it's been helpful.
Alrighty, this concludes today's presentation. Thank you so much, Joe, for your time and for educating our members today. And thank you so much to our audience. Have a great day, everyone.